Due process complaint, 34 CFR Section 300.508. General. The LE must have procedures that require either party, or the attorney representing a party, to provide to the other party a due process complaint, which must remain confidential. The party filing a due process complaint must forward a copy of the due process complaint to the used State Director of Special Education in person, by U.S. mail, or by fax. Upon receipt of a due process complaint by either the LE or the used State Director of Special Education, the receiving party will notify the other agency within 1 business day, to ensure timely initiation of the process. Content of the complaint. The due process complaint must include 1. The name of the student, 2. The address of the residence of the student, 3. The name of the school the student is attending, 4. In the case of a homeless student or youth, within the meaning of Section 725(2) of the McKinney-Vento Homeless Assistance Act, 42 U.S.C. Section 11434A2, available contact information for the student, and the name of the school the student is attending. 5. A description of the nature of the problem of the student relating to the proposed or refused initiation or change, including facts relating to the problem, and 6. A proposed resolution of the problem to the extent known and available to the party at the time. Notice required before a hearing on a due process complaint. A party may not have a hearing on a due process complaint until the party, or the attorney representing the party, files a due process complaint that meets the requirements listed above. Sufficiency of complaint. The due process complaint required by this section must be deemed sufficient unless the party receiving the due process complaint notifies the hearing officer and the other party in writing, within 15 calendar days of receipt of the due process complaint, that the receiving party believes the due process complaint does not meet the requirements. Within 5 calendar days of receipt of notification, the hearing officer must make a determination on the face of the due process complaint of whether the due process complaint meets the requirements and must immediately notify the parties in writing of that determination. Complaint amendment. A party may amend its due process complaint only if 1. The other party consents in writing to the amendment and is given the opportunity to resolve the due process complaint through a resolution meeting, or 2. The hearing officer grants permission, except that the hearing officer may only grant permission to amend at any time not later than 5 calendar days before the due process hearing begins. If a party files an amended due process complaint, the timelines for the resolution meeting and the time period to resolve the complaint begin again with the filing of the amended due process complaint. LE response to a due process complaint. If the LE has not sent a written prior notice to the parent or adult student regarding the subject matter contained in the parent's due process complaint, the LE must, within 10 calendar days of receiving the due process complaint, send to the parent or adult student the response that includes 1. An explanation of why the LE proposed or refused to take the action raised in the due process complaint. 2. A description of other options that the IEP team considered and the reasons why those options were rejected. 3. A description of each evaluation procedure, assessment, record, or report the LE used as the basis for the proposed or refused action, and 4. A description of the other factors that are relevant to the LE's proposed or refused action. If an LE has not sent written prior notice to the parent or adult student regarding the subject matter of the parent's or adult student's due process complaint until after the due process complaint is received, the LE may still assert that the parent's or adult student's due process complaint was insufficient, where appropriate. Other party response to a due process complaint. The party receiving a due process complaint must, within 10 calendar days of receiving the due process complaint, send to the other party a response that specifically addresses the issues raised in the due process complaint. Model Forms, 34 CFR Section 300.509. The USP staff have developed model forms to assist parents or adult students in filing a state complaint, a due process hearing complaint, and requesting mediation. These forms are available on the dispute resolution page of the USP website, https://schools.utah.gov/special-education/resources/laws rules regulations. Mid equals 942 and TID equals 1. Parties are not required to use the state's model forms. Parents or adult students, public agencies, and other parties may use the appropriate state model form or another form or other document, so long as the form or document that is used meets, as appropriate, the content requirements for filing a due process complaint or the requirements for filing a state complaint or requesting mediation. Mediation, 34 CFR Section 300.506 General. Each LE must ensure that procedures are established and implemented to allow parties to resolve disputes involving any matter under the IDEA and the USP special education rules, including matters arising prior to the filing of a due process complaint, to resolve disputes through a mediation process. Requirements. The procedures must ensure that the mediation process 1. Is voluntary on the part of the parties, 2. Is not used to deny or delay a parent's or adult student's right to a hearing on the parent's or adult student's due process complaint, or to deny any other rights afforded under the IDEA, and 3. Is conducted by a qualified and impartial mediator who is trained in effective mediation techniques. And LE may establish procedures to offer to parents or adult students and schools that choose not to use the mediation process an opportunity to meet, at a time and location convenient to the parents or adult students, with a disinterested party who is under contract with an appropriate alternative dispute resolution entity, or a parent training and information center or community parent resource center in the state, and who would explain the benefits of, and encourage the use of, the mediation process to the parent or adult student. The USP State Director of Special Education or designee maintains a list of individuals who are qualified mediators and knowledgeable in laws and regulations relating to the provision of special education and related services. The USP State Director of Special Education or designee selects mediators on a random, rotational, or other impartial basis. The USP bears the cost of the mediation process, including the costs of meetings described in this section. Each session in the mediation process must be scheduled in a timely manner and must be held in a location that is convenient to the parties to the dispute. If the parties resolve a dispute through the mediation process, the parties must execute a legally binding agreement that 1. Sets forth that resolution and states that all discussions that occurred during the mediation process will remain confidential and may not be used as evidence in any subsequent due process hearing or civil proceeding arising from that dispute, and 2. Is signed by both the parent or adult student and a representative of the LE who has the authority to bind such agency. A written, signed mediation agreement under this paragraph is enforceable in any state court of competent jurisdiction or in a district court of the United States. Discussions that occur during the mediation process must be confidential and may not be used as evidence in any subsequent due process hearing or civil proceedings or any federal court or state court. Impartiality of Mediator. An individual who serves as a mediator, 1. May not be an employee of the USP or the LE that is involved in the education or care of the student, and 2. Must not have a personal or professional interest that conflicts with the person's objectivity. A person who otherwise qualifies as a mediator is not an employee of an LE or USP solely because he or she is paid by the agency to serve as a mediator. Resolution process. 34 CFR Section 300.510. Resolution meeting. Within 15 calendar days of receiving notice of the parent's or adult student's due process complaint, and prior to the initiation of a due process hearing, the LE must convene a meeting with the parents or adult student and the relevant member or members of the IEP team who have specific knowledge of the facts identified in the due process complaint that 1. Includes a representative of the LE who has decision-making authority on behalf of that agency, and 2. May not include an attorney of the LE unless the parent or adult student is accompanied by an attorney. The purpose of the meeting is for the parents of the student or adult student to discuss the due process complaint, and the facts that form the basis of the due process complaint, so that the LE has the opportunity to resolve the dispute that is the basis for the due process complaint. The resolution meeting need not be held if the parents or adult student and the LE agree in writing to waive the meeting, or the parents or adult student and the LE agree to use the mediation process. The parents and the LE determine the relevant members of the IEP team to attend the meeting. Resolution period. If the LE has not resolved the due process complaint to the satisfaction of the parents or adult student within 30 calendar days of the receipt of the due process complaint, the due process hearing may occur. The timeline for issuing a final decision begins at the expiration of this 30-day period. Except where the parties have jointly agreed to waive the resolution process or to use mediation, the failure of a parent filing a due process complaint to participate in the resolution meeting will delay the timelines for the resolution process and due process hearing until the meeting is held. If the LE is unable to obtain the participation of the parent in the resolution meeting after reasonable efforts have been made and documented, the LE may, at the conclusion of the 30-day period, request that a hearing officer dismiss the parent's due process complaint. If the LE fails to hold the resolution meeting within 15 days of receiving notice of a parent's or adult student's due process complaint or fails to participate in the resolution meeting, The parents or adult student may seek the intervention of a hearing officer to begin the due process hearing timeline. The 45-day timeline for the due process hearing starts the day after one of the following events. 1. Both parties agree in writing to waive the resolution meeting. 2. After either the mediation or resolution meeting starts, but before the end of the 30-day period, the parties agree in writing that no agreement is possible. 3. If both parties agree in writing to continue the mediation at the end of the 30-day resolution period, but later the parent or adult student or LE withdraws from the mediation process. Written settlement agreement. If a resolution to the dispute is reached at the meeting, the parties must execute a legally binding agreement that is signed by both the parent or adult student and a representative of the LE who has the authority to bind the LE, and that is enforceable in any state court of competent jurisdiction or in a district court of the United States. Agreement review period. If the parties execute an agreement, a party may void the agreement within 3 business days of the agreement's execution. Within 3 business days of the agreement's execution,